We're the mobs who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high, brought together by FKR. Now we're taking truth real far, and we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and side-eyed vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is hot and the truth cuts.
President, the court set this matter today for the status hearing to address a few matters. I think we've been in such a position now where we will be able to set some upcoming court dates to get this matter proceeding forward. We've been waiting on a KCPC evaluation to be done on the defendant that has been completed. It is currently under seal. As procedure is done standard in any type of case such as this. That matter right now is under seal. There's been a motion for the KCPC evaluation to be unsealed. Mr. Barley, that's the main purpose for that is you wish to, if the court does set an evidentiary hearing and the other two motions, you wish to have that as potentially used in.
That's correct, Your Honor. Our intention is to have it for the purpose of those evidentiary hearings. I believe that it contains, without speaking about what it contains specifically, Judge, I believe that it does contain valuable information that the court would be able to use, particularly in the bond hearing in terms of coming to making the court's findings that are necessary to determine whether Mr. Stines is a good candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right. And Mr. Steele, how long, you don't have to respond to that, much that yet. How long do you all have?
Judge, if you give us 10 days, I think we got it last week, so if you give us 10 days to respond to that motion. Thank you.
All right. What I would like to do though is at least see how far we can get without addressing the defendant KCPC evaluation issue. And the fact so the court has read that, so keeping that in mind, but we can address first the motion to dismiss the indictment. Who's starting?
Your Honor, I will. Chief Royal Beth, Your Honor. Your Honor, we filed a motion to dismiss on two grounds. Number one, under RCR 5.16, failure to provide or to have a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that any testimony taken in front of the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury. Can I speak to the content of the grand jury aside from what I think?
Yeah, and for first record, the court has provided a transcript and CD recording of that.
Thank you. So there's a reference to one of the grand jurors that said, in our last meeting, or in our previous meeting, and I'm paraphrasing it.
No.
And so at that point, we weren't aware of the previous grand jury hearing. And so I inquired on they did respond to me. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records. And the judge anticipated a response. But I guess, number one, what's odd about that to me is that I've done thousands of grand jury hearings, and if you want evidence brought to a grand jury is usually subpoenaed back to the hearing. I mean, there's no reason you don't have permission from the grand jury to subpoena. You send a subpoena, you subpoena the custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know. And I think the Commonwealth was making a distinction that, well, if you don't come in and raise your right hand and swear, then it's not testimony. Well, actually, the distinction is sworn testimony and unsworn testimony. And I'd submit to you that the only way if you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury said, hey, we'd like to correct this thing. Now, I will say this, I do agree that the Commonwealth can their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you feel to ask for or form their basis for asking for medical records, Judge, I think that should have been recorded, so we would have that available. And I think 526 requires it, and the remedy is that complaint shall form a motion to dismiss. I can address the other area, Judge, okay. And the second area, Judge, I really think, Kendra, that may be an evidentiary hearing, it may not, I'm not sure. Well, I'll leave that to the Commonwealth as to the response to that, but in terms of the other portion.
You're talking about the statement to make them.
Yes, sir. As to the second portion of my motion, it's based upon Commonwealth feedback here, and Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutor's community is the aluminum back case. The detective goes in and testifies and says, basically it was an aluminum back used, this woman used an aluminum back. In reality, it was a wooden stick or something like that. And in that case, the following conviction and appeal based upon that testimony being misleading, the Supreme Court sent back and said, look, if you give evidence to the grand jury, you can't mislead. The bigger debate really seems to be after that, was it does it rise to prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that falls into the without you representing the grand jury. And so when I look at the grand jury transcript, Judge, and again, without getting into the case of East report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health of Mr. Stines. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is going, and the answer is yes. That's Detective Stanford testifying. Now, first of all, probably not an appropriate thing for Mr. Stanford, Detective Stanford, to give an opinion on, but the rules of evidence, I get it. If there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and rendering an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't have died this case. Or at least they might not have died on murder. And so what I think, Judge, is that even if the court did find that this arises to the level where this case should be dismissed with prejudice, which is what we would ask, at the very least, I think this thing should be remanded back. It's sent back to the grand jury and let them hear the correct evidence. If that statement would be corrected, or at least take it out. I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that it's they can let somebody opine what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. And that's a pretty risky thing. And here, the investigation, it definitely didn't show anything. And there's other additional issues, Judge, and that's one of the things we won't have that evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on for the court to show why we believe that was missing, in addition to anything else.
And I would agree with the quite bad faith.
Yeah, I mean, Judge, I think that in the non-Baker case, they said it was reckless. I mean, it was basically, and I think it's, and I do think it's at least reckless. But I think we need to hear more about what Detective Stanford knew. What he knows now doesn't matter. I get that, it's irrelevant, right? But what he knew the day he testified is very relevant. And I can think of one witness, an attorney, who specifically said, I think he's had psychotic. And so to say that your investigation so far is showing some of the same mind, yes, I think there's at least enough there, Judge, to let me put the witness up there and ask him. And then, Your Honor, there are additional items that I think are also of concern. There's a question. I cited those, Judge, and those are additional items. If the court doesn't want me to go about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stanford. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know, we need a hearing to find out that's what I answered. Unless the court wants to certainly take an interest in issue and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, we would ask you to put on. Please.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. We would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time, there was no witness, there was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded. Myself and Mr. Steele. Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time the testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth's response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
Victims will also clearly represent the
I'm sorry, Your Honor.
you as also court representing members of the request made.
Yes, Your
There
Honor.
was no critical commentary or anything.
No, Your Honor. Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Just a point of clarification, if I understand your question. As you can imagine, nobody in the grand jury room needs to be told what case this was, or anything regarding the facts. So when we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury skin for mental health records. They began asking questions, of which we did not have an answer to. We never answered any subsequent questions other than that. That's something we're looking at. That's part of the investigation. Those matters be presented against you later. There was never, of course, at this point in time, the preliminary hearing argument had, the video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we need the records. That would have been it.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was offered by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery session. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as the Jackson case. However, the Commonwealth does not believe it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the response. All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stanford testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So, hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not 10. Exactly, Your Honor. And so I believe counsel's arguments are confusing the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stanford's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law. Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpires when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording, Your Honor. And so we do not believe that an evidentiary hearing is recorded. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted as well, Your Honor.
Just briefly reply. Yeah, Judge, so I mean, I didn't put anything, I said, leading judge. I understand we're talking about rules evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting. Oh, I get that, Judge, but my point is this. If you put that into context with what they led testify, then I think ultimately, Judge, we're throwing that evidence will show you that this grand jury is misled. I mean, the state alone, to be honest with you, the state alone, a very opinion on sanity is, in terms of, I get you on an expert judge, but if you say it, you mislead. And then, so I'm not asking the court to look at whether things should be admissible or not. That, I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but it's germane, it's their grand jury. It's not common prudence. They're the investigative body. And so the reason I cited to the things that I thought should have came in is the contrast with other things that I think they asked and never got told because the questions were replayed. And that's why we're asking for the.
I should have talked about 20,000 basis movements in the grand jury.
Sure.
I would listen to the recording.
And Your Honor, if the Commonwealth, thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat versus a wooden stick. I don't think, there's nothing even alleged in the pleading, even if you take everything in the pleading that's been said today by defense as true, it would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of the grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
All right, I'll give you more on that. Well, if I need to hold on that picture here, if not, I will hopefully we should. I think the city last night for 27% conclusion of the hearing, and then take a copy of the first name to review the first.
For sure.
All right, next we'll go to Brian.
Yes, Your Honor. Again, Gary Bartley for Shawn, Stines, Judge. And we filed our motion for the court to, it's been back quite a ways now that we filed that, but we did ask the court to kind of hold off.
I think pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond?
light of circumstance.
Absolutely, and given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would
Public
propose,
safety is a factor also.
absolutely, there are several factors, Judge, I just think that in terms of, what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash or property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
Absolutely.
any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be, in terms
I'm
of his
gonna stop
pretrial
it for a second.
service.
Pretrial risk assessment, with all candor to all parties,
Sure.
is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece to the court. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand,
something else, right? We can't just look at the charge defense.
but that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that effect. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen, that anyone's seen. And frankly, when we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charge. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went into a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death. In that case, that statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already out there the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video during the preliminary hearing.
Right.
It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to bail.
No, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to be able to introduce that.
All right. Thank you. In response,
Judge, I believe the case I cited speaks right to the issue.
all right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your Honor?
Within 10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm gonna try to expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, Your Honor.
for all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday, since today's kind of
10
shot, it's
days
weekend?
from- why don't we do this? 2 weeks from today.
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
Your
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty channels we have to go through depending on what those come back as for an expert also. So we made the council aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
No,
more
Your
to come.
All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be cleared. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, Your Honor. Thank you, Your Honor. Would like to.
What's that?
Yes, sir, we wanted to talk to him for just a minute.
Yeah, absolutely.
Take care. All rise.
Thank you.
Please start clearing the board, please.
How am I supposed to say that? Talk time with Amy in Boston and Kelly. Time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy in Boston and Kelly on the Gene.